Welcome to Legal Services Clinic Continuing Education Series, part of the Public Trust Network and the I Need to Know podcast, a collaboration of these organizations to bring you this information. It was part of the Puerto Rican Bar Association's National Conference, which is an effort to build a national platform to discuss issues concerning Puerto Rico, the Equal Protection Clause, and the Territorial Clause of the United States. Today, our course is called Redistricting and Political Gerrymandering in Light of Recent Supreme Court Decisions. The description of this course is as follows. This class will cover the history of political gerrymandering leading to the enactment of the 1965 Voting Rights Act. This class will review recent Supreme Court decisions that have limited the reach of the Voting Rights Act by eliminating the requirements of Section 5, requiring preclearance of states' procedures, which affect ballot access with the Federal Department of Justice. Review of the various state legislative mandates, including Shelby County versus Holder, which limit voter access, and what are permissible restricting considerations. During the course of this, our course, we will be discussing the history of political gerrymandering, review of the 1965 Voting Rights Act in view of what we commonly call Jim Crow laws. We'll be reviewing recent decisions of what is acceptable political redistricting considerations and look at the latest state initiatives on voter access to ballot review, state by state, of various state initiatives that could limit voter access to the ballot. We'll be looking at questions, various questions will come up. Hopefully we'll be able to get to all of it, but if not, we'll cover as much as we can. The certification of electors, which seems to have been the most recent issue, reapportionment and redistricting, how it happens. There's the one man, one vote issue, or strong constitutional, obviously, mandate. The 1% rule, 5% rule, questions of continuousness, compactness, and racial identity versus party affiliation. Those are among the issues that we'll be discussing today. And with us today, we have a really great panel. We'll start off with Professor Mark Dorosin, who is an associate professor of law and director of legal clinics and field placement at the College Florida A&M Law School. He has been a civil rights lawyer and litigator for 30 years, working to address the continuing impacts of racial segregation and exclusion in housing, employment, discrimination, environmental justice, restrictions on political participation, and racial disparities in education. Prior to joining FAMU, Professor Dorosin served as managing attorney of the Lawyers Committee on Civil Rights on the North Carolina Regional Office, and also co-director of the Julius L. Chambers Center for Civil Rights. He's taught at the University of North Carolina School of Law and was elected to the Orange County Board of Commissioners 3 consecutive times and served as chairman from 2016 to 2018. Thank you, Professor Dorosin, for joining us today. Okay. And
I'm delighted to be here. Thank you.
With us also is Professor Patricia Broussard, joined the faculty of the Florida A&M University College of Law after teaching at Howard University School of Law for 7 years. She teaches constitutional law 1 and 2, the First Amendment, advanced appellate advocacy, and advanced topics on women and the law. Professor Broussard began her legal career clerking for the Honorable George W. Mitchell of the District Court of Columbia, Superior Court. She writes in the area of human rights with specialty focus on female genital mutilation. At Howard, she received the Warren Rosen Award for outstanding teaching and service. She regularly coaches moot court and client counseling teams and serves as commissioner for the City of Orlando's Mayor Martin Luther King Commission. She is a 4-time recipient of the Percy Looney Spirit of Service Award and 5-time recipient of the Professor of the Year. Thank you so much, Professor Broussard, for joining us. Okay, and not but not least, the only young one in this group here is Cesar Ruiz. Cesar Ruiz is a litigating attorney. He's the associate counsel for Latino Justice, previously known as the Puerto Rican Legal Defense and Education Fund. For those of us who have been in this field for a long time, know the illustrious history of the Puerto Rican Legal Defense and Education Fund, have been involved for more than 50 years in civil rights litigation. And I know that Cesar, as a young attorney litigating these issues, will have his hands full for many, many years because it does seem that the voting rights is going to be an issue for many, many years to come. So thank you, Cesar, for joining us, and thank you all at the Latino Justice.
Thank you.
All right, professors, let's talk about all these stuff. Let's start with the question of the history of gerrymandering. And I want to remind everyone that if you don't know, that the Constitution leaves to the states the times, places, and manners of holding electors for senators and representatives. That's in Article 1, Section 2 of the Constitution. And that means a whole lot of things. And so, Professor Broussard, take us through the history of gerrymandering.
So I think to talk about the history of gerrymandering, you have to talk generally about the history of voting. And this whole notion of gerrymandering and really selecting for people by putting them in certain jurisdictions goes way back. It goes back to 18th century England, as a matter of fact, where they already tried it. They had this rotten roughs is what they called it. And it was where certain areas were picked and outlined ahead of time so that the fix was in. So this whole concept comes when Englanders, when the folks from the UK, well, it wasn't the UK then, but folks from England come to the colonies. So what you have when they come to the colonies is this agreement among those who come that there will be this representative form of government. So that's sort of like the starting point where you have 100 people that say, well, we don't know what we're talking about. So we pick you 8 in order to represent us and vote for us. So gerrymandering goes way, way back. It wasn't, well, at some point it was as vicious as it is today, but it wasn't recognized and it wasn't called gerrymandering at the time. And so what you had when you came to this country was this concept of only white men could vote, only white men that owned land could vote, and therefore you left out the whole population. Approximately 6% of the population elected George Washington. So what you have is you already have the fix in. And I think we walk around saying, oh, things are horrible now. And they are with respect to our voting rights, but things have never been what you could call good. Because what happened when you had one man, one vote, and only white male landowners? What white male landowners would do is they would cede part of their property to people who worked for them to give them the opportunity to vote, and then they take the land right back from them after the election was held. So this idea of always wanting a certain person, a certain population to win is long-standing in this country. My students and I often have this discussion about what's the most important right of all of the rights that the Constitution grants. And they all say, well, the First Amendment, the speech. And I say, that's not mine. Mine is voting, because voting and putting into place the people who represent you controls all of those other rights that you have. And so voting for me is paramount. The problem with voting and gerrymandering and all of these other things is we lose our moral authority when we show the rest of the world that we are willing to negotiate this right to vote. We tout ourselves as one man, one vote, one woman, one vote. We are this great, nation that sits on the hill, shining star. We went to South Africa when Mandela ran to protect the vote. So we are the ones saying to the rest of the world, not only do you want to have a democracy, you want to have a democracy like we have. When you do that, when you try to convince people, you have to have the moral authority to do so. And I would say in the last 50 or 60 years, we are slowly but surely getting rid of that moral authority that we have. How do we tell Venezuela how to vote? How do we tell the Cubans how to vote? How do we tell France how to vote? We don't have the moral authority because of what we have done to our voting system. So you now have a name for it. You now have this name gerrymandering that emerged in Boston. But we have so many other tools that are used to both discourage people from voting and to control the vote. So I think that my concern is that we are not as educated as other societies with respect to voting. We don't understand the value of it, and we are willing to cede our rights for other things that in the long run really don't mean anything. So that's just a synopsis of voting. And I want to add something about not only voting, but not only gerrymandering, but about what we've done to voting in general. What happened after those 13th, 14th, and 15th Amendments were passed? What happened after that 15th Amendment gave Black men the right to vote? What happened after they said, we're going to use this right to vote, whether we like each other or the candidate or not, we are going to vote. And when those Black men came together and they voted, you saw something you had never seen in this country before. You saw a formerly enslaved man become the sheriff of his town. You saw Congress people go to the District of Columbia and serve. That was, and Black people in this country have always been the canary in the coal mine. So when you see what happens to Black people when they attempt to vote, that is telling the rest of the country what's going to happen. Because it was shortly after the election, the first election that Black men were allowed to vote in this country, that you have all of the shenanigans that popped up that we're going to discuss today. So just generically speaking, we've always been a little shady and shaky with respect to voting in this country. There have been some highlights, the Voting Rights Act, for example, but generally speaking, we don't and we haven't practiced what we preach. Thank you.
Thank you. Professor Dorosin, I wonder if you could then take us to the 1965 Civil Rights Act. Why did we need that? And perhaps go into the Jim Crow laws explanation and take us to why we needed to have that law.
I'd be happy to. And I want to actually, I appreciate my colleague, Professor Broussard's fantastic introduction. It's always inspiring to hear her talk about voting. One thing, and this sort of goes to the question about why did we need a Voting Rights Act, is as Professor Broussard talked about, when we talk about the right to vote, we often talk about the having the right to vote, but there's actually nothing in the Constitution that gives any person the right to vote. We have the 15th Amendment, which said the vote couldn't be denied on the basis of race. We have the 19th Amendment that said the vote couldn't be denied on the basis of gender. But there is not actually an affirmative constitutional right to vote, which is why we had all of the, the legal and extra legal manipulations of the voting process, beginning in the middle of the 19th century and continuing, well, today. What we saw, because of the absence of that affirmative constitutional right, is repeated manipulations beginning as soon as African-American men got the right to vote. And that's all who got the right to vote with the 15th Amendment. African-American women were left out until the 19th Amendment. What we saw is a series of measures taken by states. And as you mentioned in the introduction, states constitutionally control the process of elections. So what we saw was a series of state laws designed to fundamentally disenfranchise Black voters. And those measures were challenged legally and continuously upheld by the Supreme Court. So first you had grandfather clauses, then you had poll taxes, literacy tests, what was called the white primary, when the court said that overt exclusion of Black voters from elections was unconstitutional. States said, well, we're going to have primaries. Those are going to be controlled by the political party, so there's no government action, so there's no constitutional violation. So you have this series of continuing legal legal disenfranchisement of voters, coupled with, of course, what we know is the, horrific history of extra legal state-sanctioned violence against Black voters and potential Black voters, continuing all the way through the middle of the 20th century. Then in the beginning of the 1960s, we start to see the first changes. There is there's the one person, one vote case, Baker versus Carr, where the court for the first time weighs in on apportionment, which had been for the entire history of the country argued as a non-justiciable political question. But the court finally agreed that the way states were refusing to reapportion as Blacks moved to the cities and continued to draw the line so that rural voters had way more power to elect leaders than urban voters. So you have the court strike that down in the early 60s. Then we have the Civil Rights Act of 1964, which addressed a range of Jim Crow laws, primarily around segregation in employment, in federal spending, and in public accommodations, but specifically did not include voting rights. That took more legislation, another year, the continuing protests by civil rights leaders, the marches in Selma, and then eventually the 1965 Voting Rights Act gets passed. And that proves to be at the time, the effort to eliminate all of the methods of disenfranchising Black voters. And it becomes, and we may talk more, I want to hear from everybody, but it becomes what really the most successful Civil Rights Act in American history, right? If you look at the statistics, and I don't have them right in front of me, but if you look at the number of Black voters registered in the South in 1960 compared to 1966 after the Civil Voting Rights Act passes, you see it goes from very low single-digit numbers to extraordinary voter registration, and then that in turn leads to increased participation, and then the election of Black political officials. Very similar to what happened during Reconstruction, following the passage of the 15th Amendment. So you see, there's a little bit of deja vu all over again. And we see this expansion of rights. We see this mass commitment to political engagement by formerly excluded people of color. And then we see a huge contraction by the state. 65, we have the Voting Rights Act passed. We see that same kind of extraordinary outpouring of participation and commitment to exactly what Professor Broussard said, the promise of democracy and the right to vote, and through that to engage the whole panoply of civil rights. And now we see the continuing contraction of that again. And so all right. I don't know if you wanted me to go into details of the Voting Rights Act itself, or someone else could do that. As a
former state legislator myself, I like to bring up some real live understanding to what you just said in Baker versus Carr, the one man, one vote, so that people understand significance of that, because that was not in the Constitution. And so what the Supreme Court declared that one man, one vote meant the following. For those of you from Florida, you'll know that we used to have something that was called the pork chop gang. And Florida was originally populated in the north, where the plantations were in Jacksonville and Pensacola, Tallahassee. Well, as it started population, the population started moving into Miami and that Miami-Dade area. The voting for Tallahassee was based on the county. Each county would have a certain, so it was based on county, not on population. So the bigger the population, the counters, the older counties had excess power relative to the amount of people in their counties, and so therefore you could control the legislature despite the fact that you didn't have the actual population. So that's how Baker versus Carr affected. All of a sudden said, well, they say, trees do not vote, right? The famous one, trees do not vote, people vote. And so it required now that the states have to, in their power within the Constitution to direct the elections, had to take into consideration the fact that it's populations. And that then born this question of the racial gerrymandering stuff. So, or actually population now. So let me ask you, Cesar, if you would now take us, now we've got the 65 Voting Rights Act, and it had some important protections, including those protections of preclearance. Could you talk to us about that portion?
Yeah. So the Voting Rights Act was the greatest piece of civil rights legislation. I definitely agree with Professor Dorosin. It really set the standard on standards for voter intimidation. So from the moment of registration on through casting your ballot, there were protections against bad actors intimidating you from the right to vote. Another key feature of the Voting Rights Act was something you alluded to, vote dilution, preventing people's vote from not being having the same weight, more or less. And then the third piece, which there are many others, is Section 5 and preclearance. And this was the crown jewel of the Voting Rights Act. And this is because it set a standard that made states that had a long history of discrimination, they had to pre-clear any changes, policies, or practices that had a significant or some impact on minority community members, so Black voters, Latino voters, Asian voters, by the Department of Justice. And so this is a critical tool because it puts the burden on the state to justify any change that they make in their election law, and it has to overcome that barrier to even pass the law. So why is that important? A, it stays the effect of the new change in law before it can go in effect and have that negative impact. That's important because it prevents the injury to the voter while you make that determination of what kind of impact it's going to have. The second piece of it is that burden shifting piece means that the state has to create justifications that overcome that burden to show that it won't have a discriminatory effect. Now we fast forward to 2013, Shelby County v. Holder. One of the holdings of that case was that the formula to determine which states were covered by it was no longer functioning. And what that meant was that the burdens that were initially put on states that had bad actors and that had a long history of discrimination no longer had to go through this process. And what resulted from that was a slew of legislation that attacked the right to vote. And this is coming on the heels of, this was 2013, but we saw most of the prominent forces come after the 2020 election, where we had seen historic records of turnout from communities of color, of Black, Latino, Asian community members. And so we went from having one of the greatest protections to really a significantly diminished and still kind of on a lifeline, even with the other tools, right? We mentioned Section 2, which prevents vote dilution. That has been under attack in the courts, and I'm sure we'll discuss that. Section 5, without that formula, can't determine and essentially can't function to impose on the states the burden that they need to prove that these laws aren't discriminatory. And what we've seen as a result is that hundreds of laws have been passed that make access for communities of color, historically marginalized communities, to make it harder for them to vote. And we've seen that impact in every election ever since that. And that cannot be understated. Along with the long history, we have had issues with voter turnout that directly correlate to voter suppression and to gerrymandering, which kind of form the basis for a lot of the issues that we see in the electorate today.
Let me throw this.
It's worth no. I'm sorry. Go ahead, Pat.
I want to throw this question out, so I'll open it up to now, because what basically Cesar has said is that Shelby versus Holder, Shelby County case versus Holder eliminated the formula, this preclearance. So just to repeat what you said, prior with the 1965 Voting Rights Act, certain states that already had been a history had to pre-clear, right? Before they changed any of the voting procedures. And remember, we started off by saying that Constitution gives the states the right to proceed to run the election. So it's up to them to run the election. How they do it is, is a different question. what rules they apply. That's why we had the Jim Crow laws, and which were trying to stop people from voting. So now when Shelby, when they struck that, it made it more difficult for the Department of Justice in order to challenge Texas or Florida or whatever they had. It made it more difficult to challenge, right? So am I correct with your interpretation, correct? Yes. All right. So now it doesn't stop it though, right? It does allow you one by one to be able to challenge. So I was going to throw it out to all you guys who would like to answer this question. What have you seen after Shelby? What has been the result of that Supreme Court decision saying, basically the Supreme Court said, that's an old formula. It was for old situations. It doesn't count anymore for modern United States, and therefore it's unconstitutional as applied. So who would like to answer that question?
So I would like to just back up for a minute before we go into that. When my colleague said, Black women got the right to vote with the 19th Amendment, on paper they got the right to vote. But remember, in the South, at that point in time, the mass majority of the population before that great migration to the North were Black people. So Black women on paper got the right to vote. But as he said, with the percentage of people who were voting, Black women didn't get the right to vote until the Voting Rights Act was in full force. So I wanted to say that. And then I wanted to say about the Voting Rights Act. I did a brief to the United States Supreme Court in Shelby County versus Holder. And what was so important about Section 5 and all of that was that the little things like saying, you can't change the precinct without contacting us. You can't do X, Y, and Z without going either before this 3-panel or before the Justice Department, before the court. There were controls in place for the little things that we take for granted. In fact, when they had the oral argument on Shelby County versus Holder, Ruth Bader Ginsburg leaned over the bench and said to Shelby County, I'm not sure you're the right plaintiff in this case because of your behavior. What's going on here? So I think that we have to put some perspective around this, around why we needed a Voting Rights Act. My colleague, he talked about lynching, losing your job, having your house bombed, having your children harmed, all of the horrific things that happen to people of color in this country just trying to vote. I often talk about the Black National Anthem, when people say, what is this Black National Anthem? Why are you singing this lift every voice and sing till earth and heaven ring with the harmony of liberty? And I say to them that, yeah, we were free physically when this song was written, but we were so disenfranchised. We were not free to participate in the franchise of what is America. So when you understand the depth of what he articulated, what Professor Dorosin articulated with what was going on in this country, you understand the power, of this Voting Rights Act. You understand the necessity for this Voting Rights Act, and you appreciate the people who put their lives on the line to enforce that Voting Rights Act, to make sure that these states were doing what they needed to do. This is what is so compelling about us having a discussion on states' rights, because time after time after time, we have seen that states behave badly when given the opportunity. We have seen that Alabama would have me picking cotton tomorrow if they thought that they could get away with it. So I think in talking about the Voting Rights Act, you have to talk about the nuances of what it accomplished, of the little things that we take for granted. What happens when a woman or a man go to vote and there's a police car stationed out front and they know that there's a warrant out for their sons or their daughters or their nephews' arrest for something minor or major that they've done? They turn around and don't go into that voting booth and vote. What happens when you can't read and you are embarrassed and there's nobody? What happens when your language isn't manifested in one of those ballots? So I think that the Voting Rights Act was so spectacular because it did put the United States on the correct moral footing that we need to be on. And to take away Section 5 is crazy, especially when immediately after Shelby County came out, there was a cure for it. Let's make every state in the union subject to the Voting Rights Act, period. And then you can't argue that certain states are being discriminated against and they fixed what was going on and they no longer do this, especially since the day after the Voting Rights Act was struck down, Section 5 or 6 states already passed laws that were a detriment to voting. So I
Yeah.
at that.
Exactly right.
I just want to pick up on that last point that Professor Broussard made, right? The Shelby County decision didn't happen out of the blue, right? This was part of a campaign to destroy the Voting Rights Act that began not long after it started, and as Professor Broussard pointed out, there were states that were subject to Section 5 that had voting rights, voter suppression laws in the wings, waiting, laws that would never have passed if they had been subject to preclearance. There was no question that these laws had discriminatory impacts on Black voters, racial impacts, but they held that. And then in the weeks after Shelby County, North Carolina, Georgia, host of states passed the most restrictive voter suppression laws that we had seen in this country in 40 years. The other thing to keep in mind about Shelby County, before we get to what happens after, is, John Roberts, the Chief Justice, voting rights has been his white whale from the beginning. He clerked for Rehnquist, who was, very credibly, charged with voter suppression when he worked for the Goldwater campaign in Arizona in the 60s. Roberts clerked for him. Rehnquist was a extreme opponent of voting rights. After the Voting Rights Act passed, it was passed by Congress repeatedly, overwhelmingly, nearly unanimously. In the early 80s, the Supreme Court made a decision led by Rehnquist to suggest that you had to prove intent to make a voting rights claim. The Congress quickly amended the Voting Rights Act to correct that. And John Roberts, who was a young attorney in the DOJ in the Reagan administration, wrote a memo arguing for Reagan to veto that against approving the voting rights amendments. Fast forward, Roberts becomes the Chief Justice. A few years before Shelby County, there's another voting rights case, kind of went under the radar, came out of Texas. It was about the election for a water utility. And the question was whether this water utility was subject to the Voting Rights Act because, and the surface level issue was this district didn't exist when the Voting Rights Act was passed. So how could the Voting Rights Act apply to it? And the court held that it didn't. And in that opinion, Roberts signaled that it may be time for the Voting Rights Act to go away. Please, someone bring a case to take it on directly. The Northwest Water case did not. Shelby County comes up, and it's a coordinated effort by conservative judicial activists, a man named Edward Blum, who was upset because he ran for Congress in a majority-minority district. He's white, he lost, he felt like he had been discriminated against, and he then bankrolled the whole operation. And so Shelby County was not the kind of careful reconsideration of a law. It was a coordinated conservative legal agenda that was done to strike down this most, as Professor Broussard said, the most critical protection, that preclearance requirement. And states were poised to take advantage of it and did take advantage of it the day it passed.
I think that that's the important point here, so that we don't give the perception of that this is all our opinion. It is in fact, as you've indicated, that after the Shelby decision, issue of preclearance, immediately several states, including the mentioned Texas, and including Texas, began a process of limiting voter access. So let's concentrate on what does that mean, because people who are taking this course may have no idea what we're talking about when they say limiting voting or limiting voting rights. So going back to the definition, then I'm going to turn to you, Cesar, and I'm going to ask your son. The Constitution says that times, places, and manners of holding electors for senators, representatives left with the state legislature. So that means, for example, whether you have one polling station in a county or you have 10 polling stations in a county, it's a state issue. So if you want to limit the ability of people to vote in a very large district, all you have to do is say one polling station. If you want to make it easy for people to vote, you put 10 polling stations. If you want to make it difficult, you put the polling stations in maybe another county where you have to require to travel. You can limit the time. You can limit the places and the manner. So that is how these states are able to limit voting. So I would like to, with your experience of what you studied, what have you encountered as to the times, places, and manners of holding elections?
Yeah, I think that's an important point, that it broadens, it's broad, this conception of state rights, and the voting rights always acted as a check to that concept. There's always been wide discretion for how states conduct their election, as long as it was not violating equal protection, the 14th Amendment, which is also a jurisprudence that's under attack, and also so long as it wasn't compliant with the Voting Rights Act. So you couldn't show that race predominated any part of that decision making in any way. And without preclearance, without that burden, and without that rigorous analysis that had to be conducted, states are now free to regulate elections in ways that they see fit. And oftentimes it is discriminatory. The burden that Section 5 proved was to stymie some of that. But now in this context, private litigants, individual citizens have to file cases to challenge these practices. And what we've seen is that states have passed laws that restrict access to vote by mail, shorter early voting hours, even shorter like polling hours, less locations. We've seen attacks on, how you register to vote, who can register to vote, kind of every permutation of it attacking access at every level. And because states now don't have the check of Section 5 preclearance, they have a lot more leeway. And we also have a federal court that reads states' rights more affirmatively than other courts have. And so that has created a lot of litigation, a lot of action for private actors. The burden with that is that it puts a lot of burden on the voters. It puts a lot of burden on nonprofits. It puts a lot of burden on private citizens that are already scarce on resources, and which means that we have to be super strategic, and we can't fight every battle. We have to now pick and choose which ones rise to that level. And within the context of redistricting, there is the redistricting map, which is always something that at the statewide level and local level happens. And it's a question of how can we have all these fights? And then when we talk about the rules and the procedures, it's a question of which ones are having the most significant impact, such that we can put our limited resources to those. And we have to have our ear on the street listening to what the voters are telling us to show how we show up. And that's different from years past, where the DOJ, which has thousands of attorneys, would be all around the country, particularly in the places with history of discrimination, to bring the fight to them. And it's created a lot more harm than good. And we've seen that affect turnout across multiple elections since 2013. And then that's been a huge problem that we've been fighting against, and that we'll have to continue to, because 2013 was the beginning. Then we have 2020, which has historic turnout. But then comes the concept of the big lie, or these ideas that elections are not secure and safe. And this kind of throws into hyperdrive this concept of election integrity, which is a permutation of many of the historical things that Professor Broussard and Professor Dorosin mentioned. This idea that states have this outsized influence of how elections are run, and that the federal government should not have a role, even if states are discriminating against voters of color. The second concept being that states can now use the concept of election integrity, even where it's found that elections are absolutely secure, that there's not widespread voter fraud, to intimidate voters. And that's been the second permutation that we've seen. We've seen the criminalization of voting in Florida with individuals who were granted the right to vote who were formerly incarcerated. They've imposed fines and fees, which we argue is a new form of a poll tax on people who are historically Black and Latino who are over incarcerated. And then we also see the creation of election integrity police task force, which only serve to prosecute crimes of election integrity and to intimidate voters again. So a lot of what we've seen in the past have now recreated itself. And in part, it's because we've lost Section 5, but it's also, I think, as Professor Dorosin mentioned, activists within the court reading laws the most restrictive, and that harm is borne ultimately by the voter.
Can I just add, but the irony of what you just said, and I agree with you wholeheartedly, is Bush v. Gore. So you have in Bush v. Gore, you have the state of Florida, the state Supreme Court saying, we've got this, we'll handle this, we know what we want to do. And you've got the interjection of the United States Supreme Court, which probably should have never taken the case, saying, oh, well, we know best in this instance. So it's kind of ironic that when it comes to, can you hand out water when people vote? Can you, do X, Y, and Z when people vote? Can you move? That's left to the states. But the bigger question, the biggest question probably that had been asked in decades was, who has jurisdiction over this particular case, over this process? And for the Supreme Court to declare just this once, we're going to interject into this just this once. Now, this isn't really precedent. It's really not going to count in the future until we decide it does. We're going to make the decision for the state. So the voting process has been laced with hypocrisy and so much manipulation in this country that it's very, very frustrating. And I think other nations see us and they wonder what are we doing? Irrespective of who the candidate is, who wins, how we handle ourselves with this thing that we tout as being what makes us great. One man, one woman, one vote. And we're just bungling it for the whole world to see.
All right, we've covered a whole lot, and there's still a lot more that we, of course, could discuss on this issue, like the cost of this litigation, because Professor Dorosin, yourself, and Cesar, that if now without preclearance and having the Justice Department taking on this task, now it's up to the individual case in each individual county or state. It becomes extremely expensive, and that's perhaps for another course. But we know this is where the current state of the law is as vis-a-vis the Voting Rights Act. So, but now let's get into the perfect segue. You indicated about voter dilution and the one man, one vote. We come to the point of designing districts in order to create a certain result. So perhaps, Professor Broussard, you could speak us there, and then I'd like to go to Professor Dorosin as to how do we get to the question of voter dilution, voter preference, voter for minorities, and I know also you could speak to the litigation as to how you create a majority district. So if Professor, you could take us into the question of racial gerrymandering.
So the court has said that you can't gerrymander along racial lines, but you can gerrymander along political lines, which is absolutely positively absurd when you look at statistics that say rightfully or wrongfully, let's just talk about Black people. Rightfully or wrongfully, the bulk of Black people are Democrats, right? So when you start gerrymandering along the lines of what party you belong to, automatically and implicit in that is race, because of the stance that many people of color have taken on which party they're going to support. So having said that you can gerrymander along political lines but not along racial lines, it's farce. It breaks down to mean absolutely nothing, because many times Black people are a great deal of the Democratic Party. So you end up in saying, well, we're not doing this. because they're Black, but you certainly, most definitely are doing so when you are saying, well, here's where the Democrats go, and here's where. And so when you start making these crazy, insane lines of gerrymandering, and you fix it so that, first of all, no Black candidate can ever be elected the way you gerrymander, and the fix is in for the person that I think the Ted Cruz district is the one that people use all the time in Texas, how he always wins because of the way his district is gerrymandered. So I think that it is disingenuous to pretend like you are gerrymandering around political lines when in fact you aren't. I think it's also ingenuous when you don't have a conversation about the census. When you don't talk about, okay, we're gerrymandering because we have a mandate from the census that we've taken this, every 10 years we do this census, and we decide you discourage Black people from, and people of color generally, and my other minorities from opening the door or filling in that form and mailing it in. So the census report isn't valid in the first place, or it's not all encompassing. So if these are the documents that you are using to determine how you're going to gerrymander, when you're going to gerrymander, all of that, they are incomplete. So the whole process becomes farcical to an extent, and none of it is valid because you're gerrymandering for an outcome for specific people, as opposed to there's another way to do it. If you were really interested in Black people being represented and Latino being represented, you gerrymander a district where you knew that a Black person was going to be elected, where you knew a Latino person was going to be elected. That's not the purpose of gerrymandering. It's not a good thing.
All right, so let's get into that. Let's get it. First, contextually, we have a census every 10 years. The Constitution requires a census, and therefore, and because we have one man, one vote, now the districts must be equal, right? Professor Dorosin, perhaps you could take us into how into the equality issues and how that creates the need to create a district that's more electable one way or another.
Sure. Well, I just, again, picking up on that great introduction that Professor Broussard gave, the census, we get the results such as they are, and then the district lines have to be redrawn to ensure that there's one person, one vote. So you're accounting for migration patterns within states and between states, right? Some states lose congressional seats, some states gain congressional seats because of the population changes. And so the state governments of each state then has to redraw all the lines in the state for the US House, for the state legislature, and for local elections. And those districts have to be roughly proportional in the number of people in them. That's back from Baker v. Carr. What happens then is how those lines get drawn. And as Professor Broussard said, the court had made clear that those lines couldn't be drawn based on race. And so what legislators who wanted to create racially gerrymandered districts did was then say, oh, we're not looking at race, now we're looking at partisanship. Even though, as Professor Broussard said, that's just a fig leaf. That got challenged at the Supreme Court, and the Supreme Court really in, I would say, the upside down of Baker v. Carr said, this is not justiciable. Partisan gerrymandering is not an issue that the courts can weigh in on. We won't have anything to do with it. That's right, political question, thereby legitimizing exactly what these states were doing. In North Carolina, after Shelby County, they passed a voter suppression bill where they actually asked the researchers to look at what types of voting procedures were favored or predominantly used by Black voters. And every one that was, they got rid of, right? So early voting was cut back. Mail-in voting was changed. The kind of voter ID you could use, all specifically targeted to disenfranchised Black voters. That law was struck down by the Supreme Court. A few years later, the legislature in North Carolina came back with virtually the same law, but they didn't talk about Black voters anymore. They talked about it in a partisan context, and that law went forward and is still in operation. The other reason why this gerrymandering has become even more important in the wake of Shelby County goes back to the issue of preclearance, right? Now there's no more preclearance. So the legislature draws these districts egregiously unfair. They have the same number of people roughly, but by manipulating where the lines go, they are skewed egregiously. Now, you want to, if an individual voter or advocacy group wants to challenge that, it's post hoc, right? The law is passed, and the effort is to try to then change that's in place already. And with what we know is voting rights litigation takes a long time. And there are general jurisprudential rules that say courts shouldn't make changes to voting laws too close to the election. It's called the Purcell principle. It's from a Supreme Court case. So partisan groups that want to maintain discriminatory gerrymanders, for example, can stall these cases long enough so that so we're in situations where districts that have been found to be unconstitutional still have elected representatives from those districts because of the timing and the delays of voting rights litigation. And so, so it is an extraordinary challenge. The other thing to note, to get a sense of just how bad this is, if you look at just recently, take the Florida election that just happened. If you look at the state legislative races, almost all of them are decided by margins of over 10 or 15%, right? There's, I think of all the state legislative, Senate and House in Florida, there were about 4 or 5 that were considered competitive. Every other one, either if it's gerrymandered at a Republican district, the Republican wins with over 60% of the votes. If it's a gerrymandered Democrat district, which still happens because the Republican legislature has an interest in packing Democratic voters into a district to make all the districts around it safe. And you see that there is no actual representation of voters across the state.
So
the other thing, just to talk about and I don't want to cut off Attorney Ruiz, but the other thing to think about is gerrymandering is a district-based voter suppression tool, but we're now seeing what I would call the next generation of gerrymandering, which is suppressing voters even outside of districts. Like in Florida, having a 60% requirement to pass a constitutional amendment. That's voter suppression.
Correct.
58% of the voters voted to add the abortion rights amendment to the state constitution. A clear majority. But the legislature has elevated the requirement. So you see that happening also. You see Black legislators in Tennessee getting turned out of office by the legislature, right? They couldn't gerrymander around Memphis to prevent them from electing a Black representative. What they did instead is they silenced those representatives and removed them from office. So that we're actually seeing the next iteration.
Professor Suarez, can I just interject? Because I know that this is supposed to be a teaching course that we're doing. I just want to interject to make sure that what Professor Dorosin said is understandable when he talked about something being non-justiciable because it's a political question. I don't know, how long people have been out of law school, but what he's saying is it can't go before the court because in order to be justiciable, it has to not be something that one of the specific branches of the government can hear within itself. So, for example, the courts create the rules for the courts. So if they violate a rule, as we've seen some folks arguing that Clarence Thomas has done, the court is the one that will handle it. If the House of Representatives has someone who misbehaves, even though it may be criminal in it is up to the House of Representatives to expel that person. So each branch of government has rules and regulations that it formulates for that group. And when the court says it's non-justiciable, meaning we can't hear it, the House of Representatives needs to handle that. We can't hear it. The president and the Department of Education need to handle that. So I just want to make sure people understand what is meant when you say something is non-justiciable. It's the court saying, we're not going to handle this. This isn't our purview. That falls within the purview of that branch of government that the issue has arisen in. So I just, because my students just sit there drooling at the mouth going, huh? So I know that
I know we can have a very, very, very conversation on when the courts decide it's justiciable and when it's not justiciable. And if to try to put a pin on any logic to it, it's very, very difficult. Very difficult. But Cesar, I'd like you to expand on this, the terminology that Professor Dorosin has indicated. He used the word packing, right? So in the civil rights litigation is cracking and packing. And there's also a question about the shape of a district. Could you give us what the parameters have been up to this point on this question of what is permissible gerrymandering?
Yeah, so one person, one vote is the ultimate fault line to be able to determine the districts have to be equal in size. As you can imagine, that gives state legislatures a lot of leeway to draw districts in ways that benefit them politically, and that's often what's done. And the forms in which legislatures have created ways that they stay in power is through packing, where they put as many of one racial group or ethnic group or even one political party in a district so that the other districts are less competitive. The other part is cracking. So you're splitting the communities such that they're spread across so many districts that they can never form a majority and be able to elect a candidate of their choice in that particular district. And the protections that we have in the causes of action are under Section 2. So in 1986, Thornburg v. Jingles was a case that decided how Section 2 of the Voting Rights Act protected against vote dilution. It had essentially 3 requirements. The first was that you have to be able to form a majority in a district. So you have to have enough population. It's a 50+1 rule generally. The second is that the minority groups have to be politically cohesive. So this makes sense because you want a district where people are going to be empowered to vote and that they'll see a candidate of their choice be elected. The last is that you have to prove the injury or the harm or that the white majority is voting against that interest. And that's important because you're able to show that without that white-black majority voting, that there would be no harm. And the second kind of cause of action really deals with equal protection. This is where you maybe don't have enough population, but it's clear that race predominated the drawing of a district. And this can come in many forms through packing, cracking, through the movement of certain populations. And I really want to hit on a point that both Professor Dorosin and Broussard talked about, the concept of minority groups that vote so cohesively such that partisanship can be a proxy for race. And we saw this in the South Carolina case. Now, historically, courts had been able to, take apart the two. They could recognize when something was a racial gerrymander by saying they moved all of these people from one racial group into this district, and it was clear that it had a racial intent or race predominated that decision making. What we saw most recently in a case in South Carolina was that the court found that that was not the case. So what happened in that case was they moved 30,000 Black voters, 90% of which voted Democrat, into a new district, and the state made the argument that, oh, this was not because of race, it was political. And as you all mentioned, they framed this as a political question, which is a convenience of the court because there were many political questions this cycle on cases that came forward, and that was not the case. But they made this argument and they said, no, it's not political or it's not racial, it's political, and we don't have a place to say. And what they essentially did was they heightened the bar. They say you have to show more. And that is significant because it heightens the bar of you showing, oh, they moved all this racial group into another district, they packed them, they cracked them, they did all the things you're not supposed to do. But they said, oh, no, they're all Democrats, so it's okay. And that's significant because it's really changed the way that equal protection, a place where you may not have a Section 2 protection of the Voting Rights Act, and created a higher burden. And even with Section 2, the most recent case, Milligan, which affirmed Section 2, is on edge because the way that the courts have interpreted is so narrowly to limit how these causes of action are brought.
Right. So that case was the South Carolina case that you mentioned earlier about that they now have to show more in order to try to distinguish whether they're politically gerrymandering or whether it's racially gerrymandering, which makes the job just that more difficult from the purpose of litigation, which again, we could get into the litigation about how you prove cohesiveness. And when I teach the issue of cohesiveness, I often use the question of Puerto Ricans and Cubans. You know, they're both Hispanics, but they're not cohesive. And so it's an easy one for more people to understand when they're trying to understand what is cohesiveness. And then, but each one of the factors you just mentioned that have to be proved is a difficult burden in order for the litigant to be able to show that the state was using the rules and the power within the Constitution in order to create a certain result, which would be a violation with a race-based or gender-based. Right? So this is all very difficult. Let's end up with the question of some solutions to racial gerrymandering. In Florida, there is a constitutional requirement, and in some other states, not just Florida, that the districts be drawn by nonpartisan panel. Who would like to address that issue and knows about how other states may be addressing that issue? Cesar, can you address that?
Yeah, I'm happy to get it started. So there, with a recognition of the gridlock in the federal government, and with also just a recognition that the federal courts are not a friendly forum for civil rights issues, a lot of the action has turned to State Voting Rights Act to restore protections at the state level for minority voters. And a big part of that is reestablishing preclearance provisions on local entities that have a history of discrimination. And so in New York, we passed it, but in Florida, there's also a bill before the Senate and the House trying to restore these protections. And that's where a lot of the action has been to try and restore some of these protections. The second part is what you mentioned. There's also been an effort to create protections in state constitutions. Last cycle, Florida passed Article 3, which instated a process that protected against political gerrymandering and, in theory, racial gerrymandering. And there were a series of lawsuits that determined and ultimately found some of the maps didn't pass muster and had to be redrawn. And that those protections exist at the state constitutional level as well. And they really dictate how maps should be drawn. They have some of the concepts that you mentioned earlier about compactness, and that was also an issue that you mentioned. Districts cannot be drawn in these crazy ways. They have to be drawn in a way that makes sense. They have to be compact, contiguous. They have to all be, you have to be able to walk from one end of the district to the other, which makes sense. And all of these things are also built into state constitutions to check the power of political actors who often act in their political best interest, which isn't always in the interest of the voters. And so the two forms are really State Voting Rights Act and state constitutional provisions, which Florida has the state constitutional provisions that dictate that process and take some of that discretion away from people that are drawing, because most voters are alienated and sick of politicians drawing their lines, and they want fair lines and fair representation.
Great. Go ahead. Go ahead, Professor. Go ahead.
But even when the court comes forth, or even when some outside entity comes forth and they say, this is crazy, this doesn't make sense. Was it Alabama was told, you got to redraw this map? And they said, we're not going to redraw it. No, make us. And so what happened was the court had to step in, the government had to step in and redraw a map for them. So you had this whole a throwback to the 1950s, this massive resistance. We're not going to do it. We don't want to do it. And I wanted to add a little fact that popped into my head to what Mark talked about earlier when he was talking about Justice Roberts clerked for Rehnquist. Well, Rehnquist clerked for Justice Jackson. And Justice Jackson was in the hospital at the time when Brown versus Board of Education was being discussed among the justices. And Rehnquist wrote memo after memo to Justice Jackson saying, vote against Brown versus Board of Education, leave Plessy in place. And this was withheld from the public during his judicial hearing when he went up for his hearing before the Supreme Court. So I just thought that that was an interesting fact, especially when Professor Dorosin said, you know, this thing goes way back. It's not, this is a setup. This isn't something that just popped up. So you have Roberts to Rehnquist to Justice Jackson, and probably even further back than that. But you have this resistance going on in the country where people said, we're not going to do it. We're going to do it our way. We're going to, we've got an alternate group of folks we're going to appoint. So they're not even following their own rules in the states. And so when it gets to the Supreme Court or it gets to a higher being, they say, no, we're not going to do it. And that's what happened in Alabama when they said, your map clearly violates the Constitution. They said, make us fix it, and refuse to do anything. So
We have
that's what
come,
we're up against.
we are coming to the end of this class, and obviously there is a lot to discuss. This is part of the continuing education program of the Puerto Rican Bar Association, and our effort to try to create a national platform, right, for this issue we consider the equal protection issue vis-a-vis the citizens of the island, and those of us who have relatives who still live there and consider this a problem. But civil rights is an old, well, I guess, how do we do it? It's part of our American fabric of our Constitution, going all the way back to establish who has the right to vote. But it seems to be that a lot of young lawyers are not attracted to the field as either being esoteric or not relevant, or it's not me. You know, I'm going to go business lawyer or something like that. I was wondering if we could end with a sort of a discussion on all of you who have given your life to this issue as to how you would urge and what you would urge young lawyers who are listening to us as to whether or not this is a field they should consider for the future. And I'll start with you, Professor Broussard.
Well, I think, first of all, it's probably not sexy or attractive or money making, some people think, but especially students. And then when they get out there, they find none of it is sexy, and all of it is hard work. And I think that they don't realize, a lot of young people don't realize how detrimental it is to have people out there on the front lines protecting our rights before they're all gone. And then we turn around and who were the gatekeepers? Why wasn't anyone aware? I think protecting civil rights, I think pro bono work, I think doing what Professor Dorosin and Professor Ruiz or Mr. Ruiz, and what you have done is so important, and it goes unrecognized, but it's the only thing between us and having this Constitution collapse. It's the only thing. Lawyers who are dedicated, who are serious. I don't know if you guys remember, but when the Muslim ban was passed and folks were having trouble getting in and out of the country, a flock of lawyers were at the airports. A flock of lawyers who were dedicated to human rights and civil rights showed up. That made the difference. They filled the gap. So what all of you guys have done, you're filling the gap. Is it sexy? No. Is it hard work? Yes. Is it work that keeps you up at night? Yes. Is it sometimes you feel like you're taking 2 steps forward and 3 steps back? Yes. But you are the gatekeepers. You are the ones who stand in guard of the Constitution. And in standing guard of that Constitution, you're standing in guard of democracy. You're standing in guard for our children, our grandchildren, our great-grandchildren. So I think that we need to get out there and we need to talk about what we do, what our values are, what is at stake. And we have to do this more and more to young lawyers. And I hope that there are some young lawyers who are out there who will hear this. Even if you don't want to change what you do some pro bono work. Go out and do some pro bono work in this area. Start by just registering people to vote and talking to people and understanding the sacredness of my favorite right, the right to vote. Thank you.
Professor Dorosin?
Well, I just would echo everything that Professor Broussard said. I think, as lawyers, we have specialized training and specialized skills that are really integral in helping the country fulfill the promises of democracy. And, it's been said a million times, but it's always worth repeating. The great quote from Charles Hamilton Houston, who said, "A lawyer has to be a social engineer, or else you're a parasite on society." And so and I think that transcends partisanship. It transcends almost everything except the commitment that we should all have to the rule of law and to the fundamental rights that we all hold so dear, including the right to vote. And so, there's great work to be done, and there's going to be more of it to be done. And we need people who are willing to make that challenge. As Professor Broussard said, it's hard to do, and it's easy to get discouraged. But we're striving, all of us, to really fulfill these promises. I talked to a student recently who said they were, frustrated by the outcome of the election, and they didn't know if they wanted to be a lawyer anymore. And I reminded her of, the work of all those amazing lawyers who fought against Jim Crow in the beginning of the 20th century, who faced more enormous odds than we could imagine, including threats of death. And they persisted, and that's what lawyers have to do. So that's what I'm going to do, and I'm looking forward to standing arm in arm with my colleagues here and throughout the profession to do that work.
And Cesar, you're the young blood who are just starting your career.
Yeah.
See, everybody here who is on this stage has been there for a long time doing this. How do you feel about it, and why do you do it?
Yeah, I mean, I think we just have to start with, hate is alive and well. Discrimination is alive and well. These are forces that are working against our best interest. For my generation, we grew up in a time where we saw the benefit of a lot of the fights that they had in the 1960s. We saw the benefit of a lot of those protections. We're living in a time where those protections are under attack: affirmative action, education, all of the things that people fought long and hard for are under attack. And that sense of urgency now, for me, is for the world that my children are living into, and my grandchildren, all that will come after me, and for the moment that I'm living in now. We know about the real issues facing this country economically. We know that that's disproportionately borne by communities of color who don't see the benefit of representation and who are alienated. And so I fight, that fight, because it's important to show people that we have leaders, that we have people that buy into the system, and we want that system to look like us. We also criticize the system and hold it accountable, and that's a part of what we do. I am a person that was always passionate about civil rights. I always wanted to help my community. I work in service of that. I know not everyone has that benefit and that privilege. As lawyers, we all have that privilege, and do what you can. If you're not able to volunteer, give back to educational institutions, to nonprofits doing the work. These are incredible professors. Support them in ways that you can't imagine, and to show up, because it may not feel like it's you today. But the way that things are headed is there's a target on every person of color in this country, and we just have to be real about that. You're not as safe as you think, and with the ways that the law is changing and the way that they're projecting the laws to change, this fight will be a lot more inclusive than you think. And so we have to get ready for that reality and stand up for our rights.
And I want to let you thank all of you, and to know that one of my ex-students is a litigating attorney at Latino Justice. So I'm proud to say that she took a great step forward. I want to thank all of you for joining.
Professor Suarez, can I just end with one thing? We, the people of the United States, in order to form a more perfect union is aspirational, and it's never ending, and we can't ever stop attempting to have a more perfect union. And that's what this is about. And that's what lawyers are about. And it's achievable, a more perfect union. I just wanted to add that. Thank you for letting me.
Bob, and those of you who are interested in our series, you know, you can click into our site and you can take on the rest of the classes that we have presented this year and last year as well. All will be on our website. Thank you all. Thank you very much.